one of the victims an Instagram direct message. Now, that message was never responded to, and it's not clear if the message just wasn't seen or ignored. Now, his account has now been deleted. And yesterday, the state amended its gag order in the case, expanding its scope, and it states in part now that the attorneys for any interested party in this case, including the prosecuting attorney, defense attorney, and any attorney representing a witness, victim, or victims, are prohibited from making extrajudicial statements concerning this case. All right, still with me, trial attorney and former criminal defense attorney here in studio, Erica Wilson, and also joining us now for the hour, appellate and trial attorney Matthew Barhoma. Thanks again, Matthew, for joining us this evening. Truly appreciating it. Let me start with you, Erica. Interesting new information, but it begs the question for me, is a connection really necessary?
Absolutely. You have to draw a connection, because otherwise, you know what I mean, you can't get to... I'm sorry, I lost my train of thought. But no, it absolutely is necessary to have a connection in this case, because the state has to show that there was some level of connection. All right,
Matthew Barhoma, your thoughts on that? This idea that I contend that with this information that looks like stalking, they have the GPS where he goes by the area where the house is 12 times leading up to the murders. To me, that's enough. You don't necessarily have to know that there was some other connection. I think that, for me, is connection enough.
You're right, Michael. You know, I always thought him canvassing the area, those phone records, that was very, very, difficult evidence to get over. Now, this added layer, now the plot thickens, right? What do you know? Why were you, contacting them? Were they targeted, right? There could be more here that actually would just only tantamount to deeper evidence, heavier weight evidence that would weigh against them.
Yeah, it certainly wouldn't hurt the prosecution's case, but my point is I don't know that they absolutely need it. Erica, I want to talk about this gag order. It's been expanded. I never like gag orders. I think they're problematic. I think you try cases on a number of different levels, but this kind of stops that. Also, we saw leading up during the investigation, they were very tight-lipped. And what did that do? That led to a lot of speculation, a lot of people being hurt, a lot of people being accused of things that they didn't do. We see some lawsuits coming out of it. Your thoughts on this expanded gag order to now include attorneys representing the families?
I think it's necessary because this is such a case of first impression. The allegations that they have led to so much crime in the city. There's been so many issues and concerns with witness tampering and witness intimidation. So I think you do have to add that extra layer of protection, even with the attorneys, because again, you want to make sure the integrity of this case is protected until the very end.
Now, Matthew Barhoma, we know that that search warrant released some information about what they grabbed up. I want to point out a couple of things and get your thoughts, because these are smaller things, but I think they're going to be very important. They seized his computer. I think that computer, and we're seeing it in the Jensen case, the live case we're covering now here on CourtTV, those computer searches, I think that's going to tell us a lot. Now, they haven't finished up with that yet. We don't have any information on it, but whatever's on that computer, I think is going to be very important. Here's something else, small thing. They got a piece of hair. Now, there's some hairs that might be human, but also something that looked like a dog hair. Now, that little tiny dog hair, there was a dog. I think Kaylee Gonzalez had a dog at the apartment. That matches that dog. Ooh, I think you got the sheath from that place. If you have a dog hair in his place, I think that's case closed.
That's that's real indicia right there. But going back to the computer, that computer could tell us a lot, and it could also link him to possible other crimes, right? So that's just a looming, loophole that could continue to feed and give a lot of information about this current case, but also about other possible cases. And each of these little pieces of evidence, Michael, they're going to tantamount to one big story, and they're going to be able to make a conviction against them that much easier.
Yeah, it creates a very nice narrative so far, at least the evidence that we've seen, and there's still plenty, I'm sure, that we haven't seen. Erica, let's turn to the Jensen case. You were here in studio with me where we had a little bit of a juror issue. Apparently, Aaron Dillard, who is the jailhouse informant, dated his sister at one point. He tells the judge, look, I want to let you know that I know this guy tangentially. He dated my sister. He had a different name at that point. He was voir dired by the prosecution. Defense didn't ask any questions. He's allowed to stay on the jury. You see any issues with that?
From the defense standpoint, I would not see any issues with that because I think, and that's the exact reason why the defense didn't ask any questions, because you want the taint, you want the jurors to kind of have that extra layer of, you know what I mean, he doesn't have credibility. Now, the state, I was surprised that they allowed him to remain, because I would have some concerns that given this information, and particularly he, in total candor, he said, you know, I don't like the way he dealt with my sister, so there may be some animus there that could cause some problems down the line. But from a defense standpoint, that's exactly what you want.
Yeah, not a problem from the defense perspective. But Matthew, he was voir dire, as I said, asked by the prosecution, do you think you can remain impartial in determining whether he's credible or not, that witness that you knew? He said yes. Is that enough to protect them? You're my appellate expert. Is that enough to protect them against some sort of appellate challenge?
That's exactly it. Why have the appellate issue? I would do away with it nonetheless, just so that it doesn't become a problem down the line, right? Is it enough? I mean, it's enough for now, and there's definitely an argument on appeal that, you know, we've gone through the right procedure to get it done, but once again, why reserve the issue for appeal? I would vitiate it altogether. That's what I would have done.
Yeah, exactly. That's what alternate jurors are for. Say, thank you, sir, appreciate it, but I'm going to let you go and let somebody take your place. But that's not what they decided to do. He's still a part of the jury. All right, Erica, Matthew, stand by. I do have to take a break. Coming up next, a Grammy Award-winning rapper is on trial for some serious charges, and now his trial has been halted, all because, you're not going to believe this, of an alleged in-court drug deal caught on surveillance.